You're watching HFO-TV.
Now I'd like to introduce Gwenn Baldwin. Gwenn is president of Baldwin Consulting, LLC. She has represented Multifamily Northwest, formerly Metro Multifamily, in the interest of apartment owners in Oregon since 2005. She's going to be giving us a legislative update on issues affecting apartment owners. Please join me in welcoming Gwenn Baldwin.
Thank you. It's really nice to be here. Angie may have taken out half of you with her speech. I'll take out the rest of you with my discussion of the legislature. So, but for those who are avid observers in Salem or the legislative process, we're in the final throes of the session. This is the interesting, wacky time when from moment to moment you're never exactly sure if they're going to wrap it up, get their job done, and leave, or we're going to be visiting each other all again in September. At this point, the one thing that I will tell you is that nobody's placing any firm bets on the last day of session other than it won't be the end of this month. But the biggest driver, and the reason why I sort of give this sort of shaping, is that all legislative sessions and all bills that are considered in a legislative session sit in a context. There are some sessions that are pretty quiet. There are some sessions that are really, difficult because of either, too much money, which can be even more difficult than not having enough money, and the nuances that come with negotiating one person's favored bill against another person's favored bill. So the driver right now, and really all session long, as if you've read the papers, you will know, is the question of how much education funding will be approved in this session and how that is available through what combination of PERS reform and revenue increases. And that's a conversation that they haven't given up having, but every time it seems like they get to a deal, it crumbles. And so it's possible that they will get to a different deal than just winding up and going home. But that's really up in the air. And the reason why it impacts the conversation around housing legislation is that depending on what the bill does related to housing and multifamily housing in particular, depends on how it's being treated or has been treated. Because if your bill requires funding of any type, it's held up by the bigger discussion. Nobody's going to move a lot of bills through that require some kind of funding if they don't know what the big funding question, how that's going to be answered. So I want to talk to you today about two bills, probably the most significant in terms of their impact on the multifamily housing world. One has already been signed into law and the other is pending for the very reason that it involves money. It also is the chief bill that was proposed by the Speaker of the House, Speaker Kotek, and so it's also tied up in the negotiations and the trades and the navigation of who gets what out of this session. So the two bills that I want to talk to you about are the Landlord-Tenant Coalition bill and the Section 8 bill. So Landlord-Tenant Coalition has been meeting for about 25 years, every year of that time frame except one, when for whatever reason, everybody agreed that there wasn't really enough going on that they wanted to address, and so they took a year off. But every other year, you have tenant advocates, landlord, property owners, and manager representatives, folks who are involved with either city or county code, and they all come together before the session starts, and they sort of put their issues out on a table and say, this is what we want to do, but this is what we want to do. You navigate, you compromise, you say this is a line that can't be crossed, and at the end of the day, there is a piece of legislation called the Coalition Bill, which is introduced into the legislative session. The value of this, and there's a reason why everybody has stuck to the table, despite when politics are not in your favor or politics suddenly become in your favor, very few people walk away, in large part because it, by its nature, ensures that the sort of worst of the worst gets sort of navigated out. Even though you have to make compromises. And it also is a really useful tool at the legislature when you have individual members who decide they are suddenly an expert on multifamily housing. And they want to make a great change. If a bill hasn't gone or an issue hasn't gone through Landlord-Tenant Coalition, it's viewed very skeptically. And so, frankly, there have been many times when we have been able to go into the legislative session and say, that issue didn't go through Landlord-Tenant Coalition, and the bill dies. So it's a useful tool. That said, there, again, as I said earlier, there are always compromises and trade-offs. So let me tell you a little bit about this year's coalition bill, because it was probably one of the meatier ones we have gone through in recent history. And there are, I will tell you, absolutely, there are things you will like, and there are things you really won't like. But it will be an adjustment for everybody. And so there are lots of opportunities, whether you belong to an association that does education and training, or whether you want to attend larger events that provide educational opportunities. I really encourage you to explore that, and I'm happy to give some information about the ones I'm aware of. So the Landlord-Tenant Coalition has 4 main components. It allows renters insurance, requiring renters insurance outright. It adds new non-compliance fees. It changes the lay of the land around screening criteria, and it increased tenant notice for foreclosures. So for those of you that have single-family homes, it's probably going to be a bigger impact than for those of you with multifamily properties because of how the bill was written. So let me walk through sort of the highlights of these. I don't want to get too deep in the weeds, but renters insurance, there was an issue and a question that was going to be litigated in court about whether or not landlords have the right to require renters have renters insurance. It frankly was one that we were, as landlords, going to lose. And we didn't want to lose it. So the way you not lose it is you go and change the law. So the coalition bill clearly defines that renters insurance is not a prohibited fee. As you know, we went from all fees are allowed except some to no fees are allowed except the ones that are specifically listed. So we made it really clear requiring renters insurance is not a prohibited fee. But what is it? So then we had to describe what renters insurance was. So this says that you can, if it is in your written rental agreement, you can have a requirement for renters liability insurance. It's silent on property insurance. So if for those of you who are in the insurance industry, you have a new market. So again, it has to be in your written agreement. You just can't sort of verbally say this is a requirement. The evidence of coverage has to be supplied by the tenant at the beginning of tenancy and at reasonable request intervals to ensure compliance. So it isn't, if somebody's boasting, oh, I got it initially, but I don't have it any longer, you can say, well, you have to show it to me, and if they don't, then that's actually considered non-compliance. And you can follow the process for people who are non-compliant. The one sort of limitation to this, and there are lots of different components, I won't get too deep into it unless you have questions, is that you cannot require renters insurance for those making 50% AFI or less, or public housing projects. And again, this was the compromise piece. Public housing projects have federal requirements, and so you can't do that anyway. But for those who are very, very, very low income, the sense was, well, they don't really have, the sort of dynamics there are different. It was a make or break for the tenant advocates. And when we checked back with the landlord representatives broadly, the vast majority of people who had liability insurance and or wanted to have it in their contracts were folks who were renting to people above 50% AFI. So that's one of those compromises. The second piece was screening criteria, and it's specifically related to prior FEDs and crime. So some of you may know that nationally there is a lot of conversation around disparate treatment and disparate impact, and that there are several cases moving through the courts nationally that would provide protected class status for criminal records. It's serious. It's moving. There's already issues related to disparate impact because the argument is that if any action impacts one protected class in a disparate nature, then it has the impact, whether you intended it or not, has the impact of discrimination and violation of fair housing laws. So in that context, the coalition was trying to figure out a different way to get at this so that we weren't going to be faced with outright protected class issues down the road. It is not perfect. In fact, this is the one area within this coalition bill where there was not 100% agreement in terms of the compromise. But let me outline for you what it is, because it is law, or will be on January 1, 2014. Dismissed FEDs. So if you filed an eviction and the person actually won, or it was dismissed, you can't consider that in your screening criteria. It's already in law. It just got clarified. FED judgments older than 5 years cannot be considered. So if somebody has a recent FED or FEDs up into 5 years, that's considered germane. If somebody has for 5 years had a good record, you can't go back more than 5 years. Arrests without charges cannot be considered, although pending arrest can be. So if somebody's been arrested and they haven't been charged yet, you absolutely can still consider that in your screening. Convictions and charging history can be considered within the following frame: drug-related crimes, sex abuse crimes, personal crimes, financial crimes, identity theft, fraud, or, and this is the big box that was the last exception, any other crime, if it adversely affects the landlord or other tenant's property, or the health, safety, and right to peaceful enjoyment of the premises by other residents, the landlord or the landlord's agent. So what this says, for practical purposes, is get your screening criteria act together. Be able to articulate, I'm not going to do anything that is going to impact negatively my tenants. So anything that could be viewed as negative to my tenants, I'm going to articulate that that's going to be a piece of my rental criteria, and then you can use it. I mean, the reality is that we live in a litigious society, and our industry tends to get, in the crosshairs a lot. And I think if folks are proactive and aggressive about how they set up their screening criteria, they'll actually be in better shape than sort of letting the dice roll on this national trend of protected class status. But this was the toughest one, because there's uncertainty both directions. So I think our job and our goal is to is to monitor this. I know Multifamily Northwest is working very hard in developing sort of best practices, screening criteria, and forms to sort of arm their folks to do it the right way and not get sideways.
Do you know the bill number on that one?
Yeah, it's Senate Bill 91A, but it's now enrolled. So it's if you go on to OLIS under the state web, you can see all the details of that. Non-compliance fees. There are 2 new non-compliance fees that are allowed: smoking in a non-smoking area and unauthorized pets. So you get those 2 in addition to the others that are currently there, and they're not a lot, but they're there. But what was done was there was a lot of conversation about, there are times when people are just, unfortunately, University of Oregon students got invoked a lot, that they can just write off $50 checks and they don't care, and it's cost of doing business, and they're violating smoking and unauthorized pets and all these other things. And that it wasn't enough of a deterrent for some folks, big deterrent for others. So the entire fee structure has been revised. Not the numbers, the types of fees are still what's in statute, plus the smoking in a non-smoking area and unauthorized pets. But the new structure says you give a warning the first time. Let them know you're not supposed to do this. You're supposed to pick up your pet refuse. Okay, all right, I'm supposed to pick up my pet refuse. The second time is the $50 warning. $50 charge. The third time is $50 plus 5% of rent. We're serious. The clock resets at a year. Frankly, if they're still doing it after a year, good Lord, do something about it, get them out of your unit. The fees have to be charged within 30 days of occurrence, so you can't let things build up and then ta-da at the end of the tenancy. It was brought up. The fees are in lieu of eviction at that step. So at any time you can say, I'm going to give you, a 3014, and you've got to address this. Or you can take one of the steps in the fee process, but you can't say, hi, here's your $50 plus 5% in rent, and by the way, your eviction notice. One or the other. And then the last piece in the landlord-tenant coalition bill is foreclosure. And this, frankly, is probably not going to affect a lot of multifamily folks. It will affect folks who have single-family properties, most likely, that are in foreclosure. And this allows a tenant, after notice of foreclosure to the rental property, so factoring in all the things that now have happened in terms of mediation and bank mediation and all that. After notice of the foreclosure to the property, the tenant can have, in a fixed tenancy, 60 days notice, can give 60 days notice to leave the property, unless the landlord provides bank notice that the foreclosure is cured, or the property has a receiver appointed by a court to oversee operation of the property. And that was the caveat that was put in to address most multifamily properties. Most of them end up, if they go into foreclosure, getting a receivership. There also were a handful of housekeeping issues. Mostly those are, and they happen every time, are the oopsies, gee, we wrote it this way, we really intended to write it that way, or the unintended consequences cleanup. But there's some things that are in the bill this time, such as addressing what 12 a.m., midnight, 12 p.m., noon actually means in landlord-tenant law, that rent means payment that gives the right to occupy the dwelling unit and the premises. And this came up in terms of garages or other storage units, some things of that nature. Again, mostly clarification. The second bill, so that bill has been signed by the governor. It is law, but it goes into effect January 1, 2014.
Thanks for watching HFO-TV. To learn more about HFO, call or visit our website. See new listings, apartment news, videos, and more when you download our apps at the Android and iPhone markets.